Good morning. Welcome to an oral argument session here at the 5th DCA. I've been introduced. Let me introduce briefly the other members of the panel today. To my right and your left, Judge Jamie Grosshans, and to my left, Judge Meredith Sasso. We've got 3 cases on the docket today. There'll be a panel change between the second and third cases, so we'll take a little bit of a recess between those 2 cases. If you do have any electronic or noise-making devices on you, please go ahead and shut those off or set them on silent at this time so that we're not interrupted. Each side gets 20 minutes in the case today. Appellant, you can reserve as much of that for rebuttal as you would like. The default setting is 5 minutes. If you want anything more or less than that, just please let me know. All right, with that, we'll start with the first case on the docket today, which is Patterson v. State of Florida. Mr. Pennell, good morning.
Good morning. May it please the court. My name is William Pennell, and I represent DARRYL Patterson, the appellant in this case. Please reserve 5 minutes of my time for rebuttal. Yesterday afternoon, I filed a notice of supplemental authority. I want to confirm the court has it. If not, I have hard copies for the court, and I have checked with the state, and they did receive a copy, and they have a copy. As noted in our briefs, the trial court committed 4 separate errors in this case. Because the error addressed in issue 3 affects both counts 1 and 2 of the information, I'm going to start with issue 3. It's our position that the prosecutor in this case asked questions and made arguments that improperly commented on Mr. Patterson exercising his right to remain silent.
But he didn't remain silent, right? He answered the question. How is that a comment on his right to remain silent? When he spoke, he answered. He just didn't give the answer expected, but he didn't remain silent, that's for sure.
So the problem would be if the state only elicited what he said, then it probably would be admissible. The problem is that the state focused on the idea that it didn't answer the specific question that the alleged victim in this case asked, and focused on it in opening, during testimony, and during closing. So the specific question wasn't, what did he say? In opening was, and she will tell you that he avoids, quote, avoids answering the question, did we have sex? So he doesn't discuss, the prosecutor doesn't discuss what Mr. Patterson says. He specifically points out that he did not answer the question. That continues into the case in chief when Ms. Fletcher testifies, where she testified, I asked him if we had sex, and the prosecutor said, did he ever answer the question of did we have sex? And after an objection from trial counsel, Ms. Terry testifies, quote, he never answered that morning, and I don't recall any time after that. So they're focusing on his failure to answer that specific question, which is a comment on his right. He has no obligation under the case law to offer an exculpatory explanation for his conduct or to provide that pre-trial, pre-Miranda.
But he did choose to answer the question. He just didn't answer it directly. And the state's question was, did he answer it or just deflect it back to you? Which is sort of what he did.
It's more than that, though. They focused on the fact that he never answered it all the way. So she says he never then answered that morning. I don't recall any time after that. So she's now testifying he didn't give an answer that morning and gave no answer to that question from 2012, the date of the alleged incident, all the way to the date of trial in 2018. So for 6 years, he never answered that question, and that's a comment on his right to remain silent. The Florida Supreme Court has clearly indicated that in a unanimous decision in Horowitz that when a defendant does not testify at trial, the state is precluded from introducing evidence of a defendant's pre-arrest, pre-Miranda silence as substantive evidence of guilt.
Do you think that Horowitz is limited to interactions with police, though?
I don't, Your Honor, and I'd point the court to the if you look at the Rao case from the 4th DCA, there's a discussion of the Florida Supreme Court's decision in Hoggins from 1998. And what Rao says when discussing Hoggins, it says, we see no significance in the fact that the defendant's silence was not a response to police interrogation.
But Rao was in the post-arrest context, right?
Right, but what Hagen says is the state constitutional right against self-incrimination extends to, quote, all evidence and argument that may be considered a comment on a right to remain silent. So, and they say that includes circumstances other than police interrogation. And they're interpreting the plain language of the Florida Supreme Court in Hagens. There's nothing in Horowitz that suggests that Hagens has been limited or that it only applies to law enforcement contact. So I think the Rao case, which is a conversation between the mother and the defendant, and the Lenz case, which is a conversation between the defendant and his wife, clearly indicate that comments on conversations between defendants and individuals other than law enforcement are protected by Article 1, Section 9, and the Florida Rules of Evidence as addressed in Horowitz.
Well, and that leads me to another question. This is, your argument is based on the Florida Constitution specifically, right? Because this is an extension, the Florida Constitution goes beyond protections provided by the federal Constitution.
It's on two bases. It's on the Florida Constitution, Article 1, Section 9, and in Horowitz, it also says a separate and independent basis for exclusion is Florida evidentiary law.
Okay, so are those arguments, in your view, preserved in light of the objection, which was common law right to silence?
I believe any judge that heard the words right to silence would know that it's a constitutional issue, but common law, I think, is just a word for case law, so a synonym for case law, so I think it's fully preserved in this case. If the judge was unsure, he certainly could have asked for clarification. The purpose of the contemporaneous objection rule is to put the judge on notice. The judge was on full notice here and had the opportunity to rule and chose to overrule the objection.
So, and the supplemental authority you filed, it looks like the second is also under the impression that Horowitz extends only to interactions with police, right? I think the language is something along the lines of interactions with police, or when a defendant remains silent during an encounter with police, the legal basis for evaluating differs depending on whether it occurred before or after arrest. It's in the Howard case that you provided. And let's just assume that's the case. And the cases that have extended Horowitz, you cite a bunch of them in your brief, those are also all limited to interactions with police.
Well, they all have.
So would we be extending Horowitz?
I don't think so, Your Honor. I think I agree with the court's question or observation that all the cases post-Horowitz happen to involve interactions with police, but there's no language in any of those cases that limits it to interactions with police. And I suggest that the Florida Supreme Court's previous decision in Hagens clearly states that Article 1, Section 9 is not limited to interactions with police.
So what constitutional concern is implicated in terms of a coercion in an interaction between individuals pre-arrest?
I think the Horowitz court says it correctly. It's not a matter of coercion. It's a matter of you shouldn't have to choose between testifying at trial and allowing the state to use your silence of evidence as evidence of guilt, and then have to rebut it with some other evidence other than your testimony. So Horowitz distinguishes the U.S. Supreme Court case in Salinas and says that we, under the Florida Supreme Court, is interpreting the Florida Constitution to indicate that it doesn't matter whether there's the coercive aspect. You're putting the defendant in the untenable position of either being forced to testify, which he has no requirement to do, or have to somehow rebut this prejudicial implication of silence, which they find is ambiguous and unduly prejudicial. So coercion has nothing to do with it under Horowitz.
Would that extend then to any evidence of consciousness of guilt that the state admits as substantive evidence?
No, it would only be interactions and statements or conversations with the defendant. Certainly, if there was evidence that the defendant ran away from their jurisdiction and there was flight, that would be evidence of consciousness of guilt. So it's only when it's evidence of silence or failure to answer a question, or failure to offer an exculpatory explanation is when consciousness of guilt is not admissible as substantive evidence, not where there's other physical or nonverbal or non-conversational evidence. Again, it's clear that if you're told that, for example, if you were told that your license would be suspended if you didn't take a blood draw, they could use that as, and then you said no, refusal evidence. That would be admissible as consciousness of guilt. If the police called you and said, we need you to come down to the station, we want to talk to you about a sexual battery allegation, and then you flew to New York, that would be evidence of consciousness of guilt. So it would not apply to all evidence of consciousness of guilt, only evidence that has to do with silence or failure to apply an exculpatory explanation. It's our position that because the prosecutor made this a feature of the case by discussing the failure to answer the question in opening, during Tanya Fletcher's testimony in its state's case in chief, and during closing, that we have prejudicial error that requires reversal of both counts.
You keep saying failure to answer the question and his right to remain silent, but I'm getting back to this. Had your client simply not said anything when the victim asked him, did we have sex? That would be a different case, wouldn't it? Your client answered the question. He did not exercise his right to remain silent. He gave an answer. What's wrong with commenting on that answer? How is that?
They didn't just comment on the answer. They certainly could have commented on the answer. They could have said, he said this, but the question was more narrow than that.
By saying this, he didn't answer the question? That's the problem?
Yes, that's the problem. The problem is he didn't answer the question. That's clear from the case law, all the cases that you can't point out that he didn't answer the question. In Howard and some of the other cases, that the defendants answer some of the questions, but when they ask, for example, were you in the house when the gun went off? They find and they don't answer, they find that that's a comment on the right to remain silent, or the defendant exercising his right to remain silent. So you can't focus on the failure to answer a specific question. That's clear in the case law. Howard says it's a high-risk error because there's a substantial likelihood that the meaningful comments will vitiate the right to a fair trial and influence the jury's verdict. It's less likely to be harmless than any other error. The court in Horowitz found it was prejudicial error because it was repeated during opening, during testimony, and in closing, which is what we have here. So it's our position that for all those reasons, the convictions on counts 1 and 2 should be reversed based on the violation of Article 1, Section 9 and Florida's evidentiary rules as established in Horowitz.
Just so I'm clear on the exact argument, in your just recent example where the police would say, were you in the house where the gun went off? If the defendant said, well, Jim was in the house, then you're saying the state could say the defendant said Jim was in the house, but they couldn't say the defendant didn't say if he was in the house.
Correct. But in our scenario, yes, they can always introduce what he said, but they can't introduce what he didn't say. And the case law is clear on that, even back to the Smith case where the defendant referenced, I believe it was the defendant didn't claim self-defense in his statement to the police, and then they wouldn't let him at trial, they wouldn't let the prosecution point out the fact that he didn't raise self-defense in his statement to police. So you can't point out what he didn't say. You can certainly point out what he says. And the question is super narrow. Did he ever answer the question? And she says, no, he didn't answer the question. And he never answered it that morning or any time between 2012 and 2018. That's the problem. Additionally, as to count 2, the trial court provided the jury with a fundamentally erroneous jury instruction because, and this is pursuant to this court's almost identical decision in Heathcock. Here, the language of the instruction instructed the jury that they could find him guilty of count 2 if they proved that he attempted a sexual battery. And this court in Heathcock said there's no such thing as an attempt to an attempt. And that reduces the burden of proof, and then under that scenario, the jury could believe that the simple act of buying a drink or driving someone to the house could constitute sufficient evidence to support a conviction.
So, assuming that the first part of the instruction, attempted to commit an act in which sexual organ attempt to penetrate, that part had too many attempts in it. Wouldn't that be cleared up by the second portion of the instruction that said, did some act toward committing the crime of sexual battery, not attempted sexual battery, but of sexual battery, especially in light of the fundamental error analysis that we're applying in this argument?
I don't think so, Your Honor. I mean, the jury's given the whole instruction. They're not told to only consider the second part. They're not told to ignore the first part. And this court in Field said if the jury's given one correct instruction and one incorrect instruction, there's no way to determine that the jury is going to figure out which one is correct, and they found fundamental error. So,
Wasn't the error in Heathcock in the second part on the attempt instruction? Isn't that the difference between Heathcock and the instruction given in this case?
I don't think so. I think that the first part of the Heathcock instruction says, I think there's an error in both parts in Heathcock, but it says, quote, in order to prove that the defendant attempted to commit the crime of attempted sexual battery, so they have a double attempt there. So it was in the first part of the instruction. And that's on page...
And that was the issue, attempted sexual battery, whereas this instruction is very clear that it's an act toward committing the crime of sexual battery, not the crime of attempted sexual battery.
I disagree that it's clear. I think that, respectfully, I think that when you tell in element one, and this deviates significantly from the standard instruction, okay? It doesn't, under standard instruction 5.1, they're supposed to initially define attempt and then define the completed offense. Here we have a definition of an attempt, and then of an attempted sexual battery, and then a definition of definition of attempt. So they've got them reversed, and then attempt to attempt is in element one, which is completely improper. So I don't think there's anything clear about it, and I don't think it's fair to let the jury decide it based on the incorrect instruction, which clearly reduces the burden of proof, as it did in Heathcock. They may have believed simply by Mr. Patterson driving Miss Fletcher home that was some attempt to attempt.
Just so you know, you're about a minute and a half into your rebuttal. So.
Oh, I was just going to say, the instruction specifically addresses the attempt to penetrate, though, not driving home.
No, but it says attempt to commit an act in which DARRYL Patterson did with his organ attempt to penetrate. So you still have the double attempt, and we know from Heathcock that there's no such thing as an attempt to an attempt. There really is no way around that, and I'll reserve the rest of my time for rebuttal.
May it please the court, my name is Chris Davenport, and I represent the state of Florida. I'd like to start with issue 3, since that's what Mr. Pennell spent the most amount of time on. The case that's most closely analogous to this one, if you assume that he didn't answer the question, which he actually did, but putting that to the side, the case that's most closely analogous is Brooks, which is cited in my brief. It's out of the 4th DCA in 2019. It's pre-arrest statement to another person and not a law enforcement officer. And the court said that's fine, that can come in as substantive evidence. And Mr. Pennell doesn't address that in his reply brief, I think, because he can't distinguish it. In his supplemental authority, it specifically says, which only makes sense, the Constitution contains a privilege against self-incrimination that confers a right to remain silent in the face of official inquiries. The Constitution protects us from the government. It doesn't protect us from each other. So it's completely different to have a pre-arrest statement, pre-arrest silent to somebody else. We have a section in the evidence code about it called adoptive admissions, and the state has to satisfy that, which was one of the problems in Horowitz, is they couldn't satisfy the requirements of that. There's no allegation they didn't satisfy it here, probably because he wasn't silent. He actually answered the question by diverting attention to how horrible the victim had acted the night before.
And was Brooks, I can't recall, was that admitted as impeachment evidence or substantive evidence?
Substantive evidence. I believe it was substantive evidence because it was pre-arrest statement to a friend. He was talking, it was one of those controlled call things. We introduce these all the time. When child sex cases, we have the kid talk to the defendant on the phone, and the defendant doesn't say anything. It's pre-arrest statement to somebody who's not a law enforcement officer.
But I think defense counsel is talking more about the silence aspect specifically, not, and I don't think he's arguing that a statement can't be used when they make a statement. But if they choose not to make a statement, is it the state's contention that that silence can be used pre-arrest, pre-Miranda, if made to an individual?
Yes, and that's what Brooks was it was the right to remain silent. That's what they were talking about in there. Yes, we're not protected from each other. We're protected from the government, and all of these other cases are the police officers go to the scene and ask the defendant what happened, and they don't want to answer, so they're just silent. And the court has said that can come in pre-arrest as impeachment evidence, but not substantive evidence.
And, I mean, I think that accurately explains the Constitution, but in terms of Horowitz, which we're required to follow, it does present it as a bright line rule.
But Horowitz
Pre-arrest
was
site.
a statement to an officer.
Do you see anything from the case, from the bright line rule announced in the case that limits it to interactions with police, other than the context?
Except for the fact that it's based on the Constitution, which doesn't protect us from each other. I think that was the issue in front of them. It was testimony from a law enforcement officer. And that's the issue they addressed. They didn't carve out an exception because it wasn't in front of them. So I'd say based on the facts of that case and all of the cases afterwards, except for this Brooks case, that's the only way to interpret it. I would also note, again, he did answer the question, and the way the state phrased it in opening and closing and in its questions was, did he answer you or did he divert it? And he did answer, and if you ask me a question about issue 1 and I start talking about issue 2, everybody knows what that means. I'm trying to change the subject because I'm not comfortable with that. And that's exactly what he was doing here. It certainly satisfied an adoptive admission. There's no indication that the defense felt otherwise. If you'd naturally answer the question in a certain way and you answer it in a different way, everybody knows what that means. Or you're trying to dodge the question. And in this case, he tried to dodge the question by talking about how awful the victim was, which is just a classic thing that people do when they're not comfortable with the answer. So we would submit that issue 3 has no merit. Certainly not harmful error. At the very least, the victim could say, I asked him if we had sex, and he started telling me how awful I was last night. That's certainly admissible. The only thing that's not is, a comment on silence. I don't think there was one. If there was, we would submit it's harmless error, especially as to count 1, where you see on the videotape him actually committing the act of putting his penis on the victim's mouth. We would submit the same thing. That videotape is powerful evidence. If the court has not watched it, we would urge you to. I would submit that makes any of these evidentiary arguments harmless. As to the jury instruction on attempted sexual battery, this is very different from the Heathcock case. In that case, they were instructed on attempt to commit an attempted sexual battery. That's not what the instruction was here. In this one, they were instructed on sexual battery in count 1, and then they said count 2 is attempted sexual battery, not attempted sexual battery like they were in Heathcock. And then they said, here's what an attempt was. That was properly defined. The only issue is if we sit and really parse that first part of the instruction, there's an argument to be made that they shouldn't have had attempt in there twice. I don't think juries do that. I don't think they sit and say, wow, there's an attempt in here twice. I think they apply some common sense, especially when it's so clear what a sexual battery is, so clear what an attempt is. I don't think they looked at it and said, well, he attempted an act that, attempted to penetrate. I think that's kind of accurate on these facts. It's certainly not fundamental error. At some point, the defendant has an obligation to object if he feels that these instructions are misleading in any way. There was no objection raised here. He never proposed a different instruction. To say that the jury could not have reached this verdict without this instruction, I would say they certainly does not meet that standard here. This could have been easily changed if he had a problem with it. Courts have said the fact that there is no objection indicates that they didn't have a problem with it below. That's how we have to read that.
They could have easily changed it in Heathcock as well. It was unobjected to there, but we
Right.
found it was
But they
fundamental.
also, in Heathcock, they instructed on a non-existent crime. I mean, it's pretty clear in here. He was instructed on attempt to commit attempted sexual battery. That's not what the instruction was here.
But the first element the jury is told they have to find is that Mr. Patterson attempted to commit an act in which he attempted to penetrate the victim.
Right.
That's not confusing? Does that lower the state's burden?
I think if we sit and focus on it, we can make any instruction confusing if we parse it down to, over and analyze it. No, I don't think that's
Not
confusing.
much parsing, that's what it
He-
says.
He
He
attempted to
act
commit an
attempted.
act upon the victim, which attempted to penetrate. I don't think that's confusing. I don't think it's an attempted sexual battery like it was in Heathcock. And again, fundamental error standard. That's a pretty high standard. The Supreme Court has said it's fundamental error if there's misleading instruction on a disputed element. When you look at the defense closing in this case, they didn't say there was no attempt or he didn't do sufficient acts towards the attempt. And if you watch the videotape, that would be an absurd argument to make to a jury. What he said was, look, the victim was awfully close to him. When you watch her in the video, she says not today, and so he didn't have sex with her that day. She was foggy on it all. We don't know exactly what had happened before the video camera was turned on. In other words, he said there's not sufficient evidence to prove beyond a reasonable doubt that the victim did not consent. That was his defense in closing. So it's not even a disputed element. It wasn't about did he take sufficient action to commit an attempt. That's not what the defense was. It was this victim's pretty shaky. She doesn't remember anything, and it's not enough. And by the way, you can't hold him to a different standard because he videotaped the sex act, and they gave a special instruction on that to show you can't hold that against him. That's not what he's charged with here. So I would submit this is not a fundamentally erroneous instruction. It's certainly different from instructing on a non-existent offense like it was in Heathcock. And the state would ask you to not expand Heathcock to this situation. Again, fundamental error. That should be a hard standard to meet. And we submit he did not meet it this time. If the court has no other questions, I would ask you to affirm. Thank you.
Thank you.
May it please the court. Initially, the state's argument that the Brooks case is controlling, I think, is incorrect. First, I think it's wrongly decided. It doesn't mention Horowitz or Hoggins, despite the fact that those are obviously applicable. Secondly, their conclusion that silence is admissible as an adoptive admission, that's a hearsay exception. That doesn't mean that the Constitution doesn't apply or the rules of evidence don't preclude it under 403. So we'd argue that Brooks is wrongly decided and factually distinguishable. Additionally, the idea that the Constitution doesn't protect conversations between defendants and non-law enforcement individuals is rebutted by Rao, Lentz, Cowan, and Hoggins. And Hoggins says, the state constitutional right against self-incrimination extends to all evidence and argument. And Cowan says the plain meaning of the phrase used in Hoggins includes circumstances other than police interrogation. So the state's just wrong about that. Finally, the argument that the jury doesn't parse the language, this whole system is based on the idea that the jury reads the instructions and applies the law as it's read to them. If they're not parsing the language, they're doing something wrong.
What do you think about the argument that that was not the defense at all? Like there was no real argument made by the defense counsel that there was not an attempt. It was more there was consent. There were they were in a relationship. That was the defense of the case. How would you then say this is fundamental
That was the
error?
defense in Heathcock. It was the exact same defense in Heathcock, and they still found fundamental error. And if you look at the Griffin case from the Florida Supreme Court, they say as long as you don't make an admission on an element, it's still disputed. So it's a disputed material element that the jury has to consider here. Nobody admitted that there was an affirmative act that constituted an attempt. So that argument, I don't think, carries weight. We assume the jury applies the law as read to them. In fact, at the end of the jury instructions, they're told that they should apply no other law than what's read to them. So when they're giving conflicting instructions, and maybe the second section is correct in isolation, the first part, it's no way to read it to say that there's not a double attempt in there and that offense doesn't exist. It reduces the burden of proof. This court's bound to follow its precedent in Heathcock. It's materially indistinguishable, and we'd ask the court to reverse on that basis. Additionally, we believe the comment on the right to remain silent is not harmless and reject the idea that the video shows it is. Certainly the video is uncomfortable to watch, but that doesn't mean that the state met its heavy burden to show proof beyond a reasonable doubt that this didn't contribute to the verdict. And under Horowitz, they found harmful error when it's addressed in opening, during testimony, and during closing, and that's what we have here. So we'd ask the court to reverse both convictions.
Thank you, sir. Thank you both very much.